We're live. We're live. Welcome everyone to another Team Talk, and a big welcome today to Paul Chamberlain and Simon Block from JMW, our principal legal partners at Team. And there's so many changes coming up with the recent government act that we really need to be in front of these, and really appreciate your investment in time, gentlemen, and your knowledge and value that you can bring to this session. I think Paul and Simon, you're going to give a bit of an overview before we do the Q&A. Welcome to all team members and guests today. We will send you a recorded session of this after the event. If you miss any key points, please feel free to put your own questions in the chat. Paul and Simon are going to give us a real overview first for 15-20 minutes, and then it's going to be open for some questions I've got for the gentlemen, but also your questions too. So thank you, Paul. Thank you, Simon. Welcome again. I'll hand it over to you, sir. Thank you.
Wonderful. Thanks, Simon. Thanks for the invitation. Great to be here with everybody. And as Simon said, we just thought we'd start with a bit of an overview just to give some context rather than launch straight into questions. So a lot of you, I suspect, will be at least aware of the Employment Rights Act. Of course, we talked about it last year very much as the Employment Rights Bill. And we were rather concerned that we might not have an act by the end of the year, but there was a flurry of activity in early December, which resulted in royal assent being given on the 18th of December, so just before Christmas. The reason for that flurry of activity was that the government, I think, were concerned that if we didn't get royal assent, or if they didn't get royal assent, some of the changes that were being planned for April of this year, most notably changes to statutory sick pay, would probably have to be deferred. So there was a political imperative to try and move matters on and get to a conclusion. But things got stuck between the House of Commons and the House of Lords. We had what we call parliamentary ping pong, where the Lords weren't backing down on certain amendments that they wanted to make, and the government was saying, well, look, these are manifesto commitments, so we really need to stick with them. So that's why we were concerned that we might not get there before Christmas. What happened was there was a meeting in a darkened room between union representatives and employer representatives, and this is no secret. Neil Carberry from the REC has made it very transparent to us that he was involved in those conversations. And there was a metaphorical knocking of heads together and an agreement reached. And the sticking point in that meeting was the qualifying period for unfair dismissal. The government had said from the outset it wanted that to be a day one right. And the Lords were not happy with that. They thought that to move from 2 years down to 0 was too significant a change and would have too much of a negative impact on the economy generally. So there was an almighty fight about it, backwards and forwards between the Lords and the Commons. In that darkened room, there was a compromise reached. The unions agreed that they would go with 6 months as a reduced qualifying period. But the quid pro quo for that, unfortunately, was the employers' organisations had to agree to abolish the statutory cap on compensation. I'll talk a little bit more about that in a second or two, but that was the compromise that was reached, and the parliamentary ping pong then came to an end, and the King was able to give royal assent on the 18th of December. So the bill, as was, is now the Act. And not all of the Act comes into force immediately. That's the way with modern legislation. The Act gets passed and there's staged implementation. So we've got staged implementation. We've actually passed one of the very early implementation dates, which was the 18th of February. I'm not going to bore you with too much detail, but A lot of the changes that came into force on the 18th of February related to trade union law, collective bargaining, and half of the Act, which runs to 400 odd pages now, half of the Act relates to trade union law and collective bargaining. So there was a repeal of the Trade Union Act 2016 on the 18th of February, which takes us back to the sort of trade union laws that we had before Margaret Thatcher was elected in 1979. So we're in a very different place now with trade unions and trade union law. I'm not going to bore you with any of that because it's convoluted and probably not of any great interest to you in this sector. But one change which was made on the 18th, or one relevant date, a relevant provision that was affected by the 18th of February commencement, was notice that people need to give for new paternity leave and unpaid parental leave. The 18th of February was the earliest date on which people could give notice to be able to take those periods of leave under the new provisions, which are elsewhere in the Act. So the 18th of February was an important date. That's come and gone. And looking forwards, the next big date is the 6th of April, where there are going to be some changes to collective redundancy law. There are going to be some strengthenings of whistleblowing legislation around sexual harassment in the workplace. So it'll be a lot easier for people to make whistleblowing disclosures, and they'll be given additional protections as a consequence of that. On the 6th of April, bereaved fathers and partners will be able to take up to 52 weeks of paternity leave if the mum or the primary adopter of the child dies within the first year of the child's life. So the mum or the adopter dies within the first year of the child's life, the bereaved father or partner will be able to take 52 weeks worth of paternity leave in those circumstances. The big change from the 6th of April is the change to statutory sick pay. And the two current rules which are in place, which means that no one who earns lower than the lower earnings limit is entitled to statutory sick pay, that's going to be abolished with effect from the 6th of April. So that will bring, we think, around 3 million workers into scope who currently are outside scope. And the other big change on statutory sick pay with effect from the 6th of April is that instead of having to be off sick for 3 waiting days before any entitlement arises, statutory sick pay will be payable from day one. And that is a very significant change generally across the economy, but specifically in this sector for those who supply temporary workers. It'll involve a very detailed and perhaps quite difficult conversation with clients around charge-out rates, because it will obviously result in increased liability for employment businesses supplying temps into clients. The other big change from the 6th of April is that another day one right comes into force. Paternity and unpaid parental leave is a day one right, and that will be effective as from the 6th of April. The following day, so it's coming thick and fast, the following day we then have the creation of the Fair Work Agency, which I think Simon and I both agree is a very positive development. It's been long promised. It was promised by Matthew Taylor back in the day when he did his report for the Conservatives last time around, but it's never happened until now. And the whole purpose of the Fair Work Agency is to bring within its scope all of the enforcement powers that a number of existing bodies have. So the Gangmaster and Labour Abuse Authority, its powers will go into the Fair Work Agency. The Employment Agency Standards Inspectorate, which you'll all be familiar with, that's the body that regulates this sector, their powers will go into the Fair Work Agency. And the HMRC's powers around compliance with national minimum wage legislation, those powers will go into the Fair Work Agency as well. So it will become a one-stop enforcement shop for workers and employees, and it'll be able to take enforcement action and bring claims on behalf of people. The whole purpose of it is to level up, so to make sure that errant employers are complying with their statutory and other obligations in the employment, in the world of employment. So that's the 7th of April, and very quickly before we launch into questions, but I hope this has been useful. It just gives you some context, that it allows you to see what's coming. The remaining timeline that we're aware of suggests that there'll be some more changes in October of this year, some fairly significant changes in January of next year, and then in later 2027, but we're not entirely sure exactly when in 2027, there are going to be some further changes. This is the current proposal, by the way. It's not to say the government will change its mind. There are likely to be some consultations on certain difficult provisions in the Act. The Act really at the moment operates as a sort of skeleton. It's the bare bones of a new regime, but a lot of the detail that needs to be attached to those bones really has to be worked through. And we suspect that that will happen as a result of some detailed consultation and then the publication of some statutory instruments. None of that has happened yet, so it will need to happen before some of the more difficult provisions come in. But that aside, the broad timeline as it's published at the moment suggests that in October, we're going to have October of this year, we're going to have the expanded duty around preventing sexual harassment in the workplace. So at the moment, your obligation as an employer is to make sure that you take reasonable steps to prevent it. With effect from October of this year, your obligation will be to take all reasonable steps to prevent it. It's a very small 3-letter word, but it makes a very significant difference to your obligations. There are going to be some further changes in October of this year to trade union law. And a particularly relevant change is the doubling of employment tribunal time limits. Most of you have had the misfortune of being, those of you who have had the misfortune of being involved in tribunal claims will know that a claimant has to bring most of the claims that they can bring within 3 months of the act that they're complaining of. So, for example, if you want to bring a claim for unfair dismissal, you've got to bring it within 3 months of the date you were dismissed. There are certain circumstances where that 3 months can be extended by up to another month, depending on when the ACAS pre-claim conciliation process starts and finishes. But the basic time deadline is 3 months. The government's proposal, and this will be effective from October of this year, is that that 3-month period should be doubled, and it will go to 6 months. Which, by its very nature, in our view, means there are going to be more claims. If you extend time limits, people who wouldn't otherwise have managed to get their claims in will now get their claims in, which will result in the tribunal having, the overstretched tribunal, having to deal with more claims. So that's October of this year. We jump very quickly to January of next year. Some big changes here. The 1st of January is when we've got the reduced qualification period for unfair dismissal protection. So that will be 6 months as from the 1st of January. But it's not 6 months from the 1st of January. If we get to the 1st of January and someone has already got 6 months service, as at the 1st of January, they will qualify to bring an unfair dismissal claim. And that's very important, because what that means is in the lead up to the 1st of January 2027, you need to have a very keen eye on any employees who may be getting close to or who may already have 6 months service. You don't want to flip over into January with an increased liability as a consequence of their continuous service. As a result of that change, there is the quid pro quo change I mentioned earlier, which is that the cap on unfair dismissal will be lifted. The cap at the moment for a standard unfair dismissal claim is about £118,000 or 52 weeks' pay, whichever is the smaller amount. So no matter what your loss is, it's capped currently at the lower of those two figures, 118,000 or thereabouts, or 52 weeks pay. Those caps will go, and what that will result in is more highly paid employees now considering bringing employment tribunal claims for unfair dismissal, because they know they will be able to get more money than they would otherwise have got before the change. And it's also going to have a significant impact on negotiations, because at the moment, of course, if we're negotiating for an employer with a highly paid employee, we can apply the statutory cap to try and manage everyone's expectations about what they might get in tribunal, and that obviously has a knock-on impact in terms of your negotiation position. That negotiation position will be lost, so there won't be that leverage available to employers from the 1st of January. They're going to have to be thinking in bigger numbers terms from the 1st of January next year. I'm not going to talk about this in any great detail, but from January as well, we're going to have changes to what it's called fire and rehire. It's not fire and rehire. This is a new regime which will allow people to bring automatically unfair dismissal claims if the employer imposes a unilateral change to their terms and conditions, and the employer rejects that change. Now, originally we thought that it would only be originally we thought that it was going to be all changes to terms and conditions that would trigger an automatically unfair dismissal claim. The government have made it clear that it won't be all changes, it will be more serious changes, so changes to more important terms like pay. So we're waiting for more details around all of that, but that new regime is effective from the 1st of January 2027. And before we get on to questions, the final point I wanted to make was, as we move towards the back end of 2027, we're going to see the regulation of umbrella companies. Those of you who've had your ears to the ground over the last couple of weeks will have seen the government's publication of a consultation document on umbrella regulation, but it goes further than that. And if you've not read it, you should, because it's also the government's proposals on how it intends to regulate the agency and employment business sector. So it's considering some changes to the conduct regulations. It's considering some changes to the agency workers regulations. So if you've been told or read that it is only umbrella reform that's been covered by that consultation document, that's wrong. It is a much wider consultation, and you should really have a look at it and get to grips with it. But that regulation is going to be effective from 2027, late 2027. More changes to collective redundancy consultation obligations, changes to flexible working, not the sort of wholesale and seismic changes that we were originally anticipating. The government are broadly saying we're going to make it marginally easier for people to make flexible working requests, and we're going to make it marginally more difficult for employers to turn a flexible working request down. So not what we were originally told was going to happen, just a little bit of tinkering around the edges in terms of flexible working. And then the big one, assuming it happens in 2027, it's planned for 2027, but it may get pushed out into the long grass. Of course, it's the guaranteed hours contract changes. Anyone on a 0 hours contract, a certain type of 0 hours contract who has regular hours is likely to have the right to be offered a guaranteed hours contract after a 12-week qualifying period. We don't yet know all of that detail. The government recognised that this sector in particular will have to be treated extremely sensitively and very carefully, because it could ride a coach and horses through the agency sector if it's not properly managed. But you need to be mindful that as things currently stand, the plan is to have those guaranteed hours contracts provisions in force before the end of 2027. Simon, that's a whistle stop through how we got here and where we're going. So I think we're now happy. Yep. If you've got any questions, or if any of the audience have got any questions, we can crack on with those.
Yeah. Sarah Burton came on a little bit late, but this is, I think, a very valid point. And it's a confusion with regard to temps and workers rather than employees. And I think we need some guidance on that. they're going to be employees somewhere, aren't they? They're going to be employees either if it's PAYE with the recruitment agency or with the umbrella company.
Yeah, a lot of the changes apply to both. The unfair dismissal changes, there's no change to the scope of unfair dismissal, so only employees are able to bring unfair dismissal claims. None of that is going to change as a result of these provisions, but there's a caveat there. Before the election, the government said they intended to completely overhaul worker status, and they were proposing to uplift workers' rights to be equivalent to the rights of employees. Now, that isn't being tackled in this Act, but it is definitely still on the agenda. So there might be a point in the future where we have workers who then have the same sorts of rights that employees have got at the moment. But at the moment, unfair dismissal protection is only available to employees. But a lot of the other things that we're talking about do apply to workers as well as to employees.
We just have Nick Wimhurst come in with an interesting question. If with SSP changes, a temp is contracted through an agency for 6 months, but signs off sick and the employer wants to terminate their contract, as the contract sits with the agency, are we liable to cover SSP for the entire 28 weeks if signed off by a doctor?
Yeah, I think this is a really interesting question. I've had to provide some advice on this recently. Terminating somebody's contract because they are entitled to SSP is an absolute no-no. If they are entitled to SSP and you want to terminate the contract for the avoidance of paying SSP, that's just not going to be acceptable. I think the key issue is that being very careful about what is the reason that an assignment might be coming to an end between a worker and a client. If the reason that you're going to stop paying SSP is because of the end of the assignment, that's not for the avoidance of paying SSP, that's because of the natural end of the assignment. They're not on assignment, and therefore you may decide that you're going to terminate the contract because there is no work that is available. But there are going to have to be some careful provisions put in place, and people are going to have to start paying very clear attention to their documentation in terms of assignments and how long assignments are for, because at the end of the day, the agency is responsible for paying the SSP. The agency worker is going to be an employed earner for the purposes of the SSP rules and the SSP regulations. So they're going to have the liability to pay that SSP, and unless they can have provisions to get that back from the client, which I think is going to be rare, they're going to be on the hook for it.
It was a good question, and Simon, a good answer too. Still in that vein, we've got Steve Bryan.
They're coming thick and fast. I knew there would be lots of questions.
They are. Who is responsible for SSP unfair dismissal claims when someone is employed by an umbrella?
Yeah, so that's if the umbrella operates the normal umbrella model, and most of them are going to continue operating the normal umbrella model, notwithstanding the changes in April. Yes, the umbrella is the employer, and most of the workers will be, if not all of them, will be engaged on a contract of employment. So the obligation to make SSP payments, the obligation around unfair dismissal, those will sit very squarely with the umbrella and not with the agency.
The umbrella will want some monies for that, won't they? In some way, shape, or form, with a contract with the.
I mean, it's interesting. We see terms between umbrellas and agencies, and there are lots of warranties, lots of indemnities. So if you're dealing with an umbrella as an agency, you need to have those terms very carefully looked at to make sure you understand exactly what you're exposing yourself to.
Here's one from Gary Strong, which I was expecting, to be fair. We provide a fair amount of staff to the construction sector who are paid via CIS self-employed. Will this affect them?
I'll take that. Yeah. So if someone's legitimately self-employed, and CIS, of course, is not necessarily a worker status issue; it's a tax issue, and sometimes there's some confusion there. CIS workers could well be workers for the purposes of this Act, in which case they will benefit from all of the appropriate worker protections in the Act. If they are legitimately self-employed, so they're neither an employee nor a worker, then no, they won't have any of the rights or benefits under this Act.
Cool. Cowpish has come in with a question. I know a lot of the focus is on temps and contractors overall, but what needs to be done for those employing staff to be ready for April, and how can JMW help out? It's putting pressure on you chaps there. There we go.
Yeah, I mean, we're experts in this sector, but of course we don't lose sight of the fact that a lot of agencies, of course, have their own employees. They've got admin staff, they've got consultants, they've got people working in the office. All of these provisions apply to them. There's no exceptions, and we're here to help with contractual changes. We're here to help educate. I mean, we're doing these sorts of things, Simon, as you'll appreciate, with clients. We're sitting there in front of clients and their managers with their HR teams, and we're talking through it all. So we're available to have those conversations.
Cool. Nick Wimshurst is firing us some questions. He wants a bit of free advice, and rightfully so. This is what this is for. It's guidance. Our team providing updated templates for temporary employment contracts that we can review. We need to check our contracts and make sure they are up to date. We are doing that. We're reviewing those now, and we'll be consulting with you, Paul and Simon, about that. So yes, that's a good question. I've got a question that I wanted to throw you guys to. I'm concerned, our recruitment business particularly exposed? We've got primarily recruitment business owners on this call, and I'm keen to really address that one. And if so, where? So are recruitment businesses particularly exposed, and if so, where?
Yeah. I'm happy to take that one. Yeah, recruitment businesses are exposed. I think it's very clear that employers are exposed and recruitment businesses are exposed as regards these changes. But if you think about some of the key points that agencies need to think about as they embark on this journey, and Paul's very helpfully set out what the time frame looks like, but the intensification of these changes is only going to ramp up. We're getting towards probably the biggest change that's coming about in April with the SSP changes, and getting ready for that. But if you think about the changes that are coming about, you've got the expansion of the definition of employment businesses to include umbrella companies, bringing more people into, or more businesses who operate in the labour supply chain. They're going to be caught by these provisions and regulatory oversight. You've got the statutory sick pay changes, as we've talked about in some detail. We've got the creation of the Fair Work Agency, as we've discussed. That's just going to shine the spotlight and allow workers to understand what their rights are, especially as regards things such as sick pay, which hasn't been paid, or holiday pay that hasn't been paid, and the ability for that agency to be able to make claims on behalf of groups of workers where they consider people are being exposed and just not treated particularly right. We've got Paul explained about the harassment duties and obligations to take all reasonable steps. So there's a legal risk where workers are operating on client sites, and agencies are going to need to make sure that they've got their processes up to speed to cope with that change. And we've also got the changes to the 0 hours rules and regulations, which, okay, there are into the future, but it's going to bring into scope much greater detailed obligations and responsibilities on agencies to work with their clients to make sure that those arrangements do work. And the figures are, there's a million people in the UK who work on 0 hours contracts. It's going to bring sharp focus. And then we've got the unfair dismissal changes. So you can see that there are, just in a quick trot through there are multiple things that are coming down the line that agencies are going to need to be responsible for and have a plan in place. And I think that's the thing that we're seeing. If you don't have a plan in place, you're not training or educating yourselves, your teams, your clients, you are going to get left behind. The message is consistent that we've been talking about since the bill was first released. It's planning and making sure that you're organised will be the key to making sure that you're prepared for these changes. And if you've got anything,
I agree with all of that. That's all extremely good advice. I suppose it's not an Employment Rights Act point, and I know you've dealt with it before, Simon, but don't forget, of course, in April we've got the joint and several liability concerns where agencies using umbrellas are going to be on the hook for any unpaid tax and NICs, and that's a big feature, which of course is only relevant to this sector. But all of the above plus that, it's not time to be complacent, if I can put it in those terms.
Where are businesses, and I mean businesses, I mean end employers, not necessarily recruitment companies, where do you see them already getting caught out? Have you seen claims or concerns coming from your wider client base, non-recruiters?
Yeah, I mean, I think it's fair to say, clearly, whilst we've got a specialism in this sector and we're spending a lot of time educating recruiters, in turn, some recruiters are asking us to go out, they're putting us in front of their clients because a lot of their clients are oblivious to a lot of this, and that's rather a surprise and a significant concern. So look, I mean, employers are employers, we're employment lawyers, we see end users get into trouble all the time, but I was saying this at another event I spoke at the other day. Our practice has changed over the last 5 to 10 years. Instead of being firefighters and dealing with problems as and when they become a problem, we do spend a lot of time now trying to educate clients to stop them getting themselves into difficulties in the first place. That's a big part of what we do.
Yeah.
And what I'm hopeful is that we'll get a lot more clients who say to us, we need you to help us with this. We need to understand what all of this means for us. And of course, we're very willing to give that sort of advice and assistance.
Well, thank you. I do think this is an opportunity for small recruitment businesses to really get under the skin of this and then educate their small companies who don't have an in-house lawyer or haven't got the budgets to have, you folks on the list. They won't be up to speed. You've already identified that. They won't be up to speed with the new legislation. They're still upset about 15% national insurance, and they're not focused on what's happening on this act. So,
and the important thing, Simon, to note is, whilst I think we thought there might be some small employer exemptions to all of these provisions, it's very clear from the act that there aren't any. So these provisions apply across the piece, whether you employ 2 people or 20,000 people. So you're not off the hook by virtue of the fact that you're a small employer.
I agree with you. A couple of questions here. Debbie Curtis, nice to have you join us. She had, if temps are paid through limited companies, will they still get the rights? We might be covering a couple of these twice, so sorry if I've done that. But what do you think?
So on limited companies, the worker is usually a director, a shareholder, and on some occasions an employee of the limited company. So the limited company wouldn't be treated as a worker or as an employee for the purposes of this act, but the individuals might have rights, but those rights would be against their own limited companies.
That's it. A good distinction. Here's an interesting one that Ellie Louise Tucker said. We've been asked by a managed service partner to pay £300 a month per client supplied for audit and umbrella checks. We are full in-house POE and already audited, but we are still being penalised and told it's mandatory. Is this allowable? It feels like a money-making exercise. Yes, it does actually. But your thoughts on that one?
Yeah, I mean, it's not an employment rights bill.
No,
issue. I think what I'd say is it sounds to me as though that's a commercial bargain. You either say yes or you say no.
Yeah.
But I suspect people will try it on.
Yeah. There was a comment from about umbrella companies and I didn't know. Do you expect umbrella to still be operating post April with the introduction of joint and several and the end user client needing to de-risk the supply chain? They will.
No, I do expect umbrellas still to be operating post April. I think what we're likely to see as a result of the umbrella changes is that there will be some consolidation of the marketplace.
Yeah,
I think there are a lot of umbrellas that exist that may struggle to cope with these changes. There's going to be a lot of risk that needs to be balanced from agencies that I've spoken with, especially some of the very large agencies. They've had to go through an exercise of reducing their PSLs down. So there was often a lot of choice out there for contractors to work with whoever they wanted to. Hearing some very big agencies would have up to 200 umbrellas on their list. That's going to contract a lot down to maybe somewhere between, figures I heard were people were using somewhere between 3 and 10 umbrellas. So I do think the umbrella market will definitely still exist, but I do think we will see some contraction in the market. There's definitely a function for umbrellas to play in this new regime. You know, at the end of the day, recruiters, the work of a recruiter has evolved over the years. They're experts in finding the labour. They don't necessarily want to operate a payroll. They haven't got the skills to be able to do that. There's a cost associated. They would rather focus on the relationship with the clients and the business of employing or engaging with that temp can be done by an umbrella company. Now, I did hear somebody talk to me about payroll bureaus the other day and why that couldn't be offered. And yeah, it is a suggestion, but at the end of the day, there's still a responsibility for people to have to monitor holiday, monitor sickness, even if you're using a payroll company. And that's hard for some smaller agencies. So I definitely believe that there is a role for umbrellas to play going forward. But what that will look like, I can't exactly tell you, but I think it will be a contracted market.
Yeah, I agree with you. And the drive was to get rid of those mini umbrellas that were looking for gaps in the HMRC processes, weren't they? That was the driver there. I'm pleased to say that through auditing that we've done, we only have FCSA or SafeRec or both, and some professional passport members as well, accredited umbrellas or membership umbrellas attached to team. But I think that and we've had several apply to us recently, and we've taken them on board if we feel they're right for our community. But someone saying, do you think recruiters may decide not to supply temps and just focus on permanent, less hassle recruitment? I think temps are an opportunity, especially, you know, some of our members have seen temp volumes rise with some of the changes that have been happening, where clients have been, where they've got project work or they want to try their temps out before they take temp to perm.
Yeah, and I think it also gives rise to another question is that are you going to get lots of clients of agencies wanting to take on lots of perm labour when you've got unfair dismissal rights that are changing to 6 months qualification for unfair dismissal? Are they going to have the headcount to be able to recruit perm labour? So you end up with a bit of a double-edged sword type question. Temp labour has been something that has been good for the economy and good for recruiters. I don't think that's just going to happen and change overnight, so that we end up with lots of people just wanting to have a perm a perm operation.
Yeah, and you know this, Simon. Income for perm placements is a bit lumpy. You know, employment businesses supplying temps. There's a consistency of income, reliable cash flow, or relatively reliable cash flow. But yes, with that comes additional obligations and responsibilities.
Yeah. Interesting question, especially regarding the new SSP relationship. So when referencing temp employees, can you ask for the sick/absence record?
Yeah. I mean, there's a common misconception that when someone tells you they're sick, you've got to treat them as sick.
Yeah.
If you think someone's swinging a lead, you've always been able to, and will continue to be able to, ask for evidence that they were in fact sick. Now, of course, if someone provides you with a doctor's note, it's very difficult to look behind that and say, well, we don't think you were sick because the doctors confirmed they were sick. But in the period of self-certification, you know, if you have someone bend your ear to say that Mrs. Smith, who said she was off sick on Monday, was actually down the pub, you know, playing snooker with her mates, or on the squash court doing whatever she did, and she was perfectly fine, you know, that's a disciplinary issue, and it may indeed give you the excuse not to pay statutory sick pay.
Yeah, and this is one of the questions that I've had when I've been asked about this recently is that how do we deal with this question of somebody might be doing this and working elsewhere? Well, you're going to have your wits around you to be able to work out, are they swinging the lead? And as Paul says, that if they are, that would be a good reason in my view, not to pay them for the SSP. At the end of the day, they are not incapable for work if they are working elsewhere.
An interesting question has just come in regards to temporary labour supplied on contract for services on week-by-week assignments. What would be the maximum days of SSP the worker can claim under the new rules?
Yeah, that sort of goes back to Simon's conversation with you a little bit earlier. With temp labour, the extent of your SSP obligation has always been quite a difficult question. It's a lot easier where you can show that you were only going to be supplying that person for a fixed period. So if you have an open-ended arrangement with a client, actually that temp might legitimately be able to claim the full 28 weeks worth of SSP, which of course is a big problem for the agency. But if you can show that the maximum length of the assignment was, for example, a week, you know you're only going to be exposed to a week's worth of SSP before you can then say, we weren't supplying you the following week, therefore you've got no SSP entitlement for the following week.
Yes, interesting for that. Steve G said, what options or examples have you possibly heard about with regards to how SSP costs for temporary workers can effectively be passed on to or claimed?
Well, it's probably fair to say that part of your charge out rate already will factor in the contingent cost. The problem is that contingent cost conceivably is going to go north now, isn't it? Because you've got earlier entitlement. I mean, if you can with a client, you perhaps should agree some arrangement with them where you can say, if we have someone who goes off sick whilst we're supplying them to you, you'll pay us for that. You'll pay us a separate sum for that. The difficulty very often is with clients, they'll say, well, if Mrs. Smith's not fit, supply us with an alternative. So they're still paying you, but they're paying you for the pleasure of supplying another worker to fill the gap, as it were.
Yeah. Jim had a good question. When referencing a candidate, can we ask a former employer if the candidate has or is currently making an unfair claim against them?
Yes. No, there's no law against that.
Excellent. Cool. I've just one's just come in from Jane. These are flying in now. With the comments regarding the fact that clients may want to go the route of temp perm, we are concerned about, we've got that in there. We are concerned about the number of temps we will lose with the 0 hours changes. A number of our clients have an agreement with us for 12 weeks, FOC transfers, but often keep them beyond this time frame before starting them perm. I always think you should have a a temp to perm contract, but I've been slightly
Yeah,
commercially greedy with that.
Well, there's nothing in the proposed new rules that are going to do away with temp to perm fees.
No.
Or indeed any form of transfer fees.
Yeah.
So the transfer fee regime under these rules is going to continue. However, if you look at the consultation document that's just been issued, the government are raising a question mark over whether transfer fees should continue in their current form. So there is going to be a question mark raised over all of that. But to Jane's specific point, what she's referencing there, of course, is that under the current proposals, after 12 weeks, someone on a 0 hours contract is going to have the right to be offered a guaranteed hours contract, and that guaranteed hours contract is with the client.
Yes.
So when she references losing the worker, that's what she means, losing the worker to the client. That's a very unfortunate conclusion the government have reached. They gave 2 options on the consultation. One, that the guaranteed hours contract should be with the agency. The second was that it should be with the end user client, and they opted for the second.
Yeah.
So yes, agencies will lose workers to clients. Whether that has an impact on the transfer fees regime, I think we've got to see what the result of this consultation is.
And there's little doubt that the consultation has addressed this point because of that very point.
Yeah.
So it's going to be a watching brief to see what comes as a result of the consultation. And bearing in mind that this change is not that the change to the 0 hours provisions is tabled for late 2027, if not beyond that.
I'm going to jump to a couple of my questions now. What policies or contracts should be reviewed now for recruitment businesses?
Well, I had this conversation with a client the other day, and it might sound as though I'm taking food out of my own mouth when I give you this reply, but it's difficult to see how any at this precise point in time need to be reviewed. We've sort of been through the timeline, and there are going to have to be some reviews. Of course there are. There are going to have to be some changes in due course. But I think the most important change is to SSP.
Yeah.
That's with effect from April. But even now, Simon, we don't know exactly what the legislation looks like to bring in this change. It's going to be a statutory instrument that brings it in. So people are saying to me, well, we know what's going to happen in April. Well, we do know broadly what's going to happen in April. But if you then ask us to change terms and conditions ahead of April, before we get the secondary legislation that's going to bring this in, we might be throwing a curveball.
Yeah.
And actually, you've wasted your time, your effort, and more importantly, your money in making those changes.
And there's been talk of since around Christmas time of some transitional provisions. And I was only looking at it the other week, and I actually haven't seen the actual transitional provisions written down as to what's going to happen to bring this into effect. Like at the end of the day, there's going to be people who are off sick as of the date that this legislation comes in. What happens to them?
Cool.
For example,
there's a couple of comments in the questions because they don't think, and rightfully, I don't think the question regarding reference checks for temps was answered fully. I thought the question meant asking a previous employer about the candidate's sick history. Yeah. Can we?
Oh, sorry, I don't think we had that question, did we? I don't think we've answered.
Yeah.
We've answered Jim's question around whether we can ask about unfair dismissal claims.
Yeah.
Asking about sickness history is a completely different bag.
Yeah.
You've got to be very careful not to discriminate under the Equality Act against people who might have ill health conditions. So you've got to be very careful. And my strong advice would be that you don't ask questions of previous employers about sick history, because if you then, for whatever reason, don't take that person on, or the client doesn't take that person on, there could be an allegation that you've discriminated against them on the grounds of their ill health.
and also, another agency shouldn't. You can't expect them to share information about somebody's sickness, health conditions. That's pretty sensitive data under data protection legislation as well. So I would never be advising anybody who came to me to say share this information with another agency.
Yeah. I've got a question about valuations of it, because there are. How does poor employment compliance affect valuation, funding, or exit? And you might have some experience in that with history, because employment compliance has been around for a long time, but it's it depends the depth of due diligence, I guess, in what funders or potential acquirers are looking at. But that could devalue a business significantly, couldn't it, if it's got poor history with regard to employment compliance, claims against it, etc., etc. So
yeah, like we've already seen this with things like holiday pay, for example. If you've never paid your holiday pay correctly, when you're trying to do an exit, and there maybe need to be provision that is made, and upon the due diligence of the business, that there'll be a reserve that's held back. I expect that these sorts of questions and getting it right are going to be things that I would expect any due diligence exercise upon the sale of a business to be looked at very carefully. And the potential fallouts from things like the Fair Work Agency in terms of potential claims that can be made. There are going to be things that any buyer, any sensible buyer, would have due diligence questionnaires in relation to. And if you're not getting it right, your requirement to provide warranties and indemnities and payments being held back for a period of time are definitely going to feature as part of any corporate transaction.
And if your sale or your purchase of a business is a TUPE transfer, which they very often are, then the seller's got to provide what's called employee liability information, which will set out things like claims that have been brought, or grievances or complaints. So yes, as part of that due diligence exercise, you should be unearthing that type of information. And it can, the TUPE liabilities can put deals off. We've worked with our corporate team where they've been in the middle of a transaction, only then to find out that when they've done the TUPE due diligence, the liabilities that they've inherited, or that would be inheriting, are sky high, and it's put the deal off. It's meant the deal hasn't happened. So it's very important that due diligence is done, as Simon references.
I'm going back to this point on sickness, referring back to the point about references and information about sickness. Is it okay to simply ask how many days sickness rather than details about the sickness itself? Or is that advised?
No, I mean, again, I'd argue there's a data protection issue, as Simon's mentioned. I think that even the number of days sickness absence is likely to be regarded as sensitive personal information. And equally, you've got to ask the question, why are you asking for it in the first place?
Yeah, okay.
You're asking for it in the first place because presumably it will inform your decision about whether to retain that worker moving forwards, which puts you squarely in discrimination territory.
Just for those people that might not know and how we think it might be applied, can we explain joint and several liability that recruitment businesses are now going to have to take with regard to umbrella companies from April to
So I'll just caveat this by saying we're not tax experts, and this is very much a tax change. But with effect from April, if you're using an umbrella company and the umbrella, for whatever reason, doesn't account to the revenue for the proper tax and NICs on its employees' behalves, instead of just the umbrella being liable, you, the agency, will also be liable. And indeed, there are other people in the supply chain that might be liable depending on the nature of the supply. So if there's a managed service company or a neutral vendor in the supply chain, they may well be on the hook as well. In some very limited circumstances, the end user client may well be on the hook. So this is all about the revenue, recognising that in the past, dodgy umbrellas that have gone bump, owing the revenue millions of pounds, the revenue have had no other way of getting hold of that cash. And what they're doing here is saying, well, we're going to change things. We're going to make it clear that we're going to come for the agency if the umbrella doesn't cough. So it is a sea change, and you know this, Simon. You and I were on a webinar very recently where we talked about this. And the watchword now is compliance. if you're using umbrellas, you've got to be all over compliance to make sure that they are properly dealing with their obligations and properly accounting to the revenue for the cash that you're paying over.
Yeah, cool. Well, thank you for that. I've got how exposed are directors going to be, do you think, for challenges would you advise that directors and officers took out insurance to cover them for some exposures that they might have?
Yeah, I think it's always sensible to look at D&O cover, and I would say that regardless of these changes.
Okay.
Look, it's always possible for directors as employees of the business to be joined into certain types of tribunal proceedings. So, for example, if there's a discrimination claim, that claim can be against both the employer company and also the person that it's alleged has done the discrimination, and that might be a director. Yeah, I would say D&O is sensible. I think there's going to be, I don't think, I know from the insurers that we know, they are looking very carefully at the Employment Rights Act to see whether they can produce new products, come up with new products, whether they can extend the scope of their cover. So if you are the type of organisation that likes to have appropriate insurances in place, then I would say speak to your current providers, or if you want us to give you some recommendations, we can do that and see what's available, because the increased liability always results, Simon, doesn't it, in creative insurers coming up with a policy to try and mop up that liability. So I suspect we're going to see more of that as we move forwards.
As we get towards the hour, gentlemen, I'm going to throw a final question at you from me. If someone wants to reduce their risk immediately, what are the first 3 steps they should take? Let's put you on the spot.
Make sure that you're well prepared for these changes. Make sure that you're not just reading everything that's out there on various platforms. Make sure it's from a reliable source. Make sure that you're training people internally to deal with these changes, and speaking with your clients. And if need be, getting the right advice to make sure that you are fully protected. I think the one consistent message that we've had from the very beginning with all of this is that if you take chances and start leaving this all to the very end, right up to the death, and not being well prepared, you are going to make a royal mess of it. If you are taking prudent steps to be informed now and using it as an opportunity to talk to your clients, I think it will be good for business and good for you to make sure that you know what's going on and that you are prepared for the changes.
Yeah, I'd add only one thing very quickly to that, Simon, and that is, given what we've said about unfair dismissal changing from the 1st of January 2027, 6 months prior to that, of course, is July of this year.
Yeah.
So if you're taking people on, or you've got people as from July of this year who are heading towards 6 months, you need to be acting very quickly if you decide they're not right for you. Please don't leave it until the 1st of January. You need to be taking some proactive steps to manage those employees in the last 6 months of this year. That's
sound advice. And the thing I'd add is be proactive. I do think this is an opportunity. I don't think most recruitment companies, and I'm not pointing the finger, won't be ready for this or understand all the intricacies of the new act, and lots of the questions that come out today confirm that, and that's from people that are closer to what's happening and what's going on. So if you can get your head around the key elements of that, put a white paper together and showcase that to your clients and potential clients, you're going to definitely raise your profile and your relationship with those organizations, especially if they're SMEs who haven't got access to legal partners like JMW instantly, or have in-house lawyers either. So there's opportunity here, definitely.
And the best recruiters, Simon, are business partners, aren't they? They're clients' business partners. They're not just providing people, they're supporting and helping their clients tackle changes like these.
Yeah, most definitely. And I've got Jim's said, is it correct to assume that all team approved umbrellas are compliant? I don't know whether they're compliant or not. We check that they are accredited or attached to FCSA, SafeRec or Professional Passport, and one isn't, but they are going through FCSA approval now, and he's got till the end of March, otherwise he will be removed, or they will be removed. Gentlemen, thank you very much for what is a tough subject. It's a subject that that the recruitment industry are learning about fast, and it's absolutely vital that we get our heads around this. And I really appreciate the time and the knowledge you've shared today. If you want, this session will be out for recording. If you want to contact Paul Chamberlain, Simon Block directly, contact them at JMW. Great supporters to team and the recruitment industry at a wider level. Thank you, gentlemen.
Thanks, Simon. Thanks, everybody.
Really appreciate that. Bye, everyone. Thank you.
Cheers.
Paul's details are on there now.